Hello, everybody. I am back for the second part of our lecture. We're going to be starting at California child welfare, so let's get going. Let's get going. Okay, so what constitutes abuse or neglect in California? So this is something that you can look up, and you probably should look up. It is not a hugely long section of law. I probably think if you print it out, it would be 2 or 3 pages. The Welfare and Institutions Code, shorthand WIC, section 300, is basically like the definitions of what constitutes abuse or neglect in California, or as your book says, maltreatment. And it has different sections to it, and I want to go through them a little bit. So physical abuse is section A. B is neglect and sex trafficking. They needed to put sex trafficking somewhere, and they just sort of slotted it into B. So B has 2 parts to it. C is emotional abuse. D is sexual abuse. E is severe physical abuse under 5. F is death of another child via abuse or neglect. G is surrender or can't provide care. H is freed for adoption, and then cruelty, and then abuse of siblings. So a couple of things. You see B a lot. You see B a lot because, you know, a lot of the conditions that these children are living in can be construed as neglect, but you almost always see a B count alongside other counts, you know. So like they'll go in, they'll investigate, and they'll find, you know, an A count, and then they'll also tack on some B counts as well. So like whatever it is that you put in the petition is things that have to be rectified by the parents, right? So like you want to get everything that needs to bring the standard of care up to minimum sufficient. And so, you know, you see combinations of these things in different configurations. Emotional abuse is super hard to prove. You almost never see a C count. It's very, very difficult to prove this because, you know, trauma is difficult to put your finger on at the best of times, and emotional abuse, like, you know, like sometimes the line between discipline and emotional abuse is thinner than you think. Sometimes it has a lot of cultural ramifications. Like it gets very messy. So like you just don't see this count very often. The E, so you might ask, why do you have both A and E? Why do you have physical abuse and then also under 5 physical abuse? And the reason why you have this is because children under 5 are particularly vulnerable. They are not able to protect themselves in a way that older kids are. And if you think about it that way, it sounds particularly terrible. But like an E count is pretty serious count. That's physical abuse of a very small child. F, thankfully, you don't see that a lot, but you do see F counts, and usually that means that the case goes to bypass. And basically what bypass means is the parents don't get reunification services. There are some things that occur where parents won't get reunification services, and this is one of those. And you know, that can be argued. Nothing is automatic, but you most likely will see that when there's an F count or when there's a G count. So for example, you know, if you are convicted of murder and you go and there's no possibility of parole and you're the only parent, that's going to be a G count, and they're going to bypass you because there's no service that they can provide to you that is going to allow you to be reunified with your child. So that's very likely to end up being a G count. Petitions can change over time, and the H count is something that happens kind of at the end of a case so that children can be freed for adoption. Cruelty, again, you don't see this very often. Cruelty is kind of like a combination of emotional abuse and something else. So emotional abuse and physical abuse, emotional abuse and like sexual abuse or whatever. I think I've only seen a couple of eye counts in my entire career. It's not something that happens very often. The court takes it really, really seriously, and often they get negotiated down to 8 counts. So like I remember one in particular, an eye count where a child was chained to the bed, I believe. That was an eye count. So yeah. And J counts abuse of siblings. So if you have a bunch of kids in the same house and only one of them is being actively abused or neglected or something, which absolutely happens, the kids who are not being abused or neglected are probably going to also come into care on J count, although they don't necessarily have to. Come on, there we go. Okay, so I want to pause on this slide a little bit and talk to you a little bit about reporting, because this is another aspect of the system where people have a lot of misconceptions about how this works. Understand a couple of things. First of all, only mandated reporters are required to report abuse. I think ethically, everybody is required. In some states, everybody is required, but in California, that is not the case. And, in California, it's a little messy, but most of the reports come from mandated reporters. But the most important thing that I want you to remember about reporting is that you don't have to do, and you should not do, an investigation. This is not Perry Mason. You are not required to know a whole bunch of details. You're not required to have proof. You should not be prying into the experiences of children, because it's very easy to re-traumatize them by making them tell you their story. All you need is suspicion of abuse or neglect. That's all you need. So there are people who have gone through extensive training so that they can investigate in a fair way and make sure that the kids are repeatedly traumatized as little as possible. That is their job. So please don't go rogue and do your own investigation. Just get as much information as is readily available in front of you and call it in. I mean, obviously you need to have enough information so that they can, find the family. You can't call in the lady who slapped her kid in the grocery store and you have no idea who she is. But if you saw her get into her car and you wrote down the license plate, they can deal with that, right? So anyway, so what you do is you call to the hotline in your county. Again, this is in California. Some states have statewide processes. You call into the hotline in your county, and you can make an anonymous report. But I want you to think very carefully before you do that, because on the kind of back end, so once it starts getting investigated, sometimes it's really useful for the worker to be able to call the reporter back and ask questions. So while you can make an anonymous report, it really is better if they have your information in the file. And theoretically, that information is not available to the parent. It's not supposed to be available to the parent, but mistakes happen. So if you have a reasonable reason to think that if the parent somehow by some mistake finds out who the reporter is and you'll be in danger, then fine, go anonymous, whatever. But think very hard about whether anonymous is the right way to go. Okay, so what happens is you talk to somebody on the phone, they ask you a set of questions, and then they say thank you very much, and you never hear another word about it unless the unless the worker who is investigating calls you back, or if, like, for example, your grandma or something, and they want to call you for placement, right? Like, let's say that they investigate and there's a problem and they want to place the children. They are likely to go to grandma who called it in first, because grandma is acting in a protective manner. Let me back up just a little bit. So when talking about who is a mandated reporter, very likely in your career, no matter what you end up doing, you're going to end up being a mandated reporter. I want you to remember one thing. You are mandated, when you're a mandated reporter, not to report everything that you see in any context. That's not the situation. If you're a mandated reporter, you are required to report what you see in the course of your employment. So unless you work in the grocery store, seeing the lady slap the kid in the grocery store, even if you're a mandated reporter, does not require you to report. Again, ethically, should you report? Absolutely yes. But are you required to? No. Okay. Anyway, so the person on the phone who takes your report, they're not going to tell you what is about to happen. But these are the options. It doesn't get investigated, because whatever it is that you've described, if it's true, does not fall under one of those, one of those categories that we just discussed on that previous slide, about what constitutes abuse and neglect. So, like, for example, here's one that comes up a lot. People calling kids who aren't going to school. Well, that is not abuse or neglect. First of all, that's a different court entirely. That's truancy court, but it does not constitute abuse or neglect. Also, being homeless does not constitute abuse or neglect, right? So, like, if it doesn't constitute abuse or neglect, it's not going to get investigated regardless. And then your other two options are an immediate, which I don't know if that's a technical term or not, but basically, like, this is what we called it when I was in Contra Costa. And immediates are, like, depending on the county that you're in, the law states that immediates are investigated within 24 hours. Usually, if it's an immediate, most counties have like a 4-hour window. They want that worker to head out like right now. They want that worker to go right now. So when we're talking about immediates, we're talking about like kids with bruises. We're talking about kids who report at school about something really serious happening at home, and we need to get involved before school is out for the day, that sort of thing. That's like a kid is in the hospital, that would be an immediate. Or a 10-day. So a 10-day is something that, like, yes, if this is true, this constitutes abuse or neglect, but it's not something where we're going to miss evidence if it sits for a few days. So it's really, really, really important that, like, however it's categorized, that it's investigated into that time frame. As appropriate, it's going to be cross-reported to law enforcement, animal welfare, whatever. So, like, if you report in your call that, I don't know, dad is hitting the child and also the dog, they're going to cross-report to animal welfare as well. Okay, so buckle in. This is quite the slide. All right, so let's say that the report is substantiated. Then what? Okay, so basically what happens is the worker has gone and has investigated and figured out that, like, oh, there is a problem here. I think that we need to do a removal, or to intervene in an emergency way. So kind of the first thing that happens here is that the petition is filed. So remember back to that slide when we were talking about WIC 300 and all of those things. And basically what a petition is it explains based on whatever category it is, what's going on. So, you know, the petition would be like the A count would be, you know, dad is, you know, hitting the kid, you know, something like that. So the initial petition is laying out what the allegations are. But again, this is within 48 hours. So there has not been a whole lot of investigation at this point. It's just what the allegations are. Okay, so at the initial hearing, often these two things happen together, by the way. But the question is there enough evidence to detain? So, you know, you've had a couple of days to put your petition together and to start your investigation, and there might be enough evidence, there should be enough evidence to detain or not. A lot of times when children have been removed based on what happens when the social worker initially shows up, which by the way is not something a social worker can do, it's something only the cops can do unless the parents agree. Anyway, at this hearing, the question is there enough evidence to keep the children? And so a lot of times children will go into an emergency placement because that's what the social worker thought that they needed to do to keep the children safe. And then 2 days later, they go home because the judge decided based on what the petition was and the evidence at the initial detention hearing that there was not enough evidence to detain the children. So that does absolutely happen. So let's say that the case continues, the children are removed, and I'm just going to go with that for now, even though there are plenty of ways in which you can go through this process and not be removed from the home. So one of those ways would be like the allegations are around domestic abuse, and the abuser has left the home. So like or let's say the abuser has been arrested. Okay, so if the abuser has been arrested, there's no reason to remove those children, right? Because they are with the other parent who is not abusing them. So like often you'll go through this process in a situation like that, and the children will not have been removed from the home. So it's a bit of a misnomer in the very first box on this slide that child is removed from the home. That's not always the case. It's just when they are first really involved in the system. So at the jurisdiction hearing, they've had theoretically enough time to do an investigation, to write a report. Everybody's had a chance to like get a lawyer, get organized, all of this stuff. And you know, there's 15 days from the detention. And the question at this hearing is, are the allegations true? Is the petition true, right? And again, at jurisdiction, it could very, very well turn out that they're not true, and like the judge rules that the children are returned, and that is that. But if they're not, at the disposition hearing, and sometimes these do occur on the same day, at the disposition hearing, the question is, what is the plan? Okay, so we've decided that the allegations are true at the jurisdiction hearing. At the disposition hearing, the question is, now what do we do? How are we going to create a situation where the parents can rectify whatever it was that went wrong so that these children or child can return back home? So at that point, once the plan has been determined and agreed to and all of that stuff, the parents have like 6 months to start getting their stuff in order. And when the kids are really little, so like if they're just like babies, they only have 6 months. And that's because, you know, this is a very sensitive period. And the court basically believes like parents really need to get it together really quickly for babies. And if they can't get it together really quickly for babies, then we need to move those babies on to a permanent home as quickly as possible to kind of reduce their trauma. So like but you can get an extension of services. So like even with a baby, you get an initial 6 months. If you're doing any kind of work on your plan at all, you're going to get another 6 months to finish if you haven't finished. For older children, you have 12 months So 2 6-month reviews to kind of get yourself in order. And again, it can be extended by 6 more months if you're kind of doing any sort of work. So that, you know, the parents have a fair shot at having the time to get what needs to get done. Now, I want to pause here and say, like, okay, so how is it then that the average length of stay nationwide is 20 months? Well, okay, so all sorts of things can go wrong here. You know, like there are all sorts of things that can happen that parents attorneys can argue the parents deserve more time because the child welfare system did not give them the services that they needed or something like that. And you will see stuff kind of go on and on for a while. That is a legal process. It is not about kind of like best interest of the child for the most part. It's about like fighting over what the law is. And the judge is always going to err on the side of caution there, because if you rush through and ram through, you know, like terminating the services on the parents, what's going to happen to you is that when you go to like the permanency hearing or the selection and implementation hearing, as you can see, they don't have the blue boxes yet, but like the parents are gonna argue, and it's gonna get really drawn out really fast. And of course, at that point, you know, kids have had you know, adoptive families identified and all of this stuff, and it can just like drag out for a really long time. So it is important that everybody does a really good job on their job the first time around, in like creating the plan and doing the reviews and making sure the parents have all the required services and all that stuff. So permanency hearings are what happens when the parents have run out of time. So like, you know, at the end of 6 months for a baby or something, or the end of the 12 months for a baby, there's going to be a permanency hearing. The question is like, are you going home? Are we done? Or well, going home does not mean you're done. It means your services get transferred to home, and you continue to be monitored at home. But like the question is, are you going home, or are you going off to adoption or some other option? So that. And then if it comes to be that the option chosen is that the child go off to be adopted, first they're going to identify an adoptive home. So first they're going to make sure that there is one. They're going to go out and find one. And because the state is not in the habit of creating legal orphans. And so what happens at the 2-6 is that the court strips the parents, the birth parents, of their parental rights. So like what this does is it clears the way for the adoptive parents to have those legal rights. So, you know, we want to make sure that adoption is well on its way to actually happening before you go on to the 2-6. So the 2-6 is like very close to the end of the process. And then the post-permanency review hearing is basically the 6-month review hearings, but without the parents. It is only about like, how is the kid doing, right? So this will happen if the child has moved on to adoptions, but after 6 months still hasn't been adopted for whatever reason, or if the child has been placed in like basically permanent foster care, which is not good, but definitely happens, especially for teenagers. And their reviews are every 6 months, just like they were before, but because the parents aren't really involved anymore, they're not part of the reports. Ooh, okay, that was a lot. All right. So a couple of things that I want to emphasize here. Permanency planning, also known as concurrent planning. So the concurrent planning is the practice of making sure that there's always a plan B. So the first plan is always to try to reunify the parents with the child, unless you're in a situation where the parents are being bypassed, as I discussed earlier, you know, like a sibling has died or something like that. Unless the parent is being bypassed, the first plan is always going to be reunification with the parents. After that, you need to be working on a parallel track, so a concurrent track. That's what concurrent planning means. Um, to see if you can make another plan. So often, let's say you have a little baby, and the parents have their plan to get themselves back in order, but also at the same time, you're looking for an adoptive home for that child. Hopefully, it's the one that they're placed in for foster care, but not always. Um, so family preservation services. So this, we don't have a crystal ball, so we don't always know when families need services before they come into care. But after they've come into care and they've worked through their plan and the children have been placed back home, it's not like, I mean, this happens sometimes, but it doesn't often happen where the court says, okay, best of luck, good luck to you, like your case is now closed. There's a period of time in which child welfare continues to monitor you, and you're being visited at home while the children are with you, and just to make sure that everything is okay. And so that's what a lot of these services are for. So reforms and myth busting. Like, there are a lot of in social work, there's a big problem where the old crusty social worker is like, I know what's right for this family, and like I've been doing this work for 40 years. And I'm not saying that there's no value to having a whole lot of lived experience in the field. There is a ton of value to having a lot of lived experience in the field. The problem is that when you get really wrapped up in your lived experience in the field, you stop looking for better ways to do things. And that's a real problem. That you start to like lose interest in evidence-based stuff, and that you should never find yourself in that situation. You should never allow yourself to lose interest in evidence-based stuff, because like that's how the field moves forward. That's how we know that kids are cared for, that families are cared for in the best possible way, is that we seek evidence, right? So in the last 20 years, there have been a lot of moves on, legislation around all of these areas. And you can look into this. Like there's all sorts of things that you can read about how this all works. But like there's been a lot of work done recently, even in the time that I worked in child welfare. And, now this is basically my job, but like in the probably what 12-ish years that I worked in child welfare, things changed a lot through legislation and through class action lawsuits and all of that stuff. So nationally, there have been some really impactful class actions in New Jersey, Connecticut, Tennessee, and Oklahoma. In California, our most recent one that really made a big splash was KDA. KDA is a class action about mental health and access to mental health services. Made a really, really, really big difference in the settlement agreement about what the agency was required to provide. So yeah, class action lawsuits are like a big means of moving the field forward. Should they be? No, but that is how it works. Overall, there's been a very big legal and philosophical move to the idea of family preservation. So like making sure that everything is kind of held together so that children never even need to leave the home in the first place. Like, is there any way that we can keep this family together without having the children go through the trauma of being removed from the home? Like, it's really, really important. It goes right back up to those evidence-based policies and procedures. And because we know now from the evidence that family preservation is like the best possible way. But if you can't do that, prioritizing kinship stuff and making sure that concurrent planning, which I just described to you, is happening, and discouraging foster families who are only interested in fostering and not in adopting the children that they have, has been really, really impactful. So like all of this stuff is really kind of mission critical. Okay, so that was a lot. If you have any questions or anything, you're definitely going to see this stuff coming up on some sort of quiz or exam or something, hint, hint. So if you have any questions, please, please come to Zoom office hours on Friday or ask your question in the forum, and we'll see how we do. All right, everybody, thanks so much for sticking with it.